The same has been filed for substitution of deceased applicant number 2. The council has submitted that the name of legal heroes and successors have been mentioned in para number.
Paragraph 5.
Paragraph 5 of the interlocutory application.
Yes, paragraph 5.
Appellant number 2 has expired on 15/8/2019. The wakalatnama on behalf of the proposed legal heroes and successors has been filed along with the interlocutory application. Let notice be issued in IA number 12410/25 to the respondents in this case through speed post, for which requisites be filed within a period of 1 week, except the deceased respondent number 1, 11, 12 and 22. इनको नोटिस दे जाएगा
जी। एक का तो हम लोग अपीलेंट का तो हम लोग फाइल कीप कर रहे हैं।
आपका अब अवेटमेंट हो गया ना, ऐसे कैसे सेटिंग असाइड है, लिमिटेशन भी है, अवेटमेंट भी है, इस तरह के मैटर्स का फ्यूचर बहुत दिन तक डिसाइड नहीं
हुआ है ना। A very young lawyer of this bar was holding the file. He died in a very grim situation in COVID. Mr. Sunil Kumar. He was holder of the file.
और भी तो सब लोग हैं।
उन्हीं के पास फाइल था, हमारे यहाँ आए थे वो। Only for marking the case.
कोविड तो 20 में आया है ना, 17 से 20 तक, 17 से 20 तक ऑर्डर 41
ये तो ठीक है।
तो झेलिए, क्या करिए, पोस्ट ऑन 1st of December, ऑफिस टू टैक्स पे पोस्ट।
आइटम 23
ऐसे केसेस जो है ना, जिसमें इतना ज़्यादा डेथ हो जाता है और ये होता है, they are already dead cases. Let's accept it. जो हमारे सिस्टम में डेड है, ठीक है, अब बस हम लोग क्रिया करेंगे। Let's take it, let's accept it. 2017 से 2025 तक substantial question of law के लिए ये मैटर प्लेस नहीं होगा। किसकी गलती I don't want to say, but this is the
I feel, my lord, that in 6 months' time, order 41 should be disposed of.
Dispose of, आप लोग कोई मेंशन ही नहीं करते, जब टेकअप होता है टाइम।
ये केस में हो सकता है।
सारे केस का वही हाल है।
सब केसेस, मतलब
प्लीज डोंट टेल मी कि केस मेंशन करने से लिस्ट है। ऑर्डर 41 का तो
पिटीशन देने से नहीं लिस्ट होता था। ये तो अभी आप आई है कि दरादर हो रहा है।
नहीं, ऐसा भी नहीं है, इतना भी नहीं हो रहा है।
अब मेरी बात को बिलीव कीजिए। I can show some.
ऐसा नहीं है, 22 साल हमने प्रैक्टिस किए हैं, मेंशन करने से हो जाता है, कभी ना कभी हो जाता है।
वो जमाना बीत गया my lord।
इतना भी पुराना जमाना का बात नहीं करते।
वो जमाना जस्टिस, अब चीफ जस्टिस का नाम क्या ले, चीफ जस्टिस मीके गुप्ता, चीफ जस्टिस वीरेंद्र सिंह, अभी मेंशन किए कल लिस्ट में।
Yes, appellant.
Yes. This is a defendant number 15 second appeal against the judgment of affirmance. The plaintiff filed title suit for declaration with right title, interest and confirmation of possession. Suit was dismissed, against which the plaintiff filed title appeal, and during the pendency of the title appeal lordship, the defendant number 15 did appellate before this honorable court to file cross objection lordship. The cross objection has not been decided by the trial court. Lordship, may kindly see the order of the judgment passed.
Then both of you must have filed appeal.
Yes, plaintiff filed appeal. That appeal lordship, the defendant number 15 filed cross objection lordship.
In the appellate, before the appellate court.
Before the appellate court lordship. That has not been considered lordship, and lordship may kindly see page 20.
Where is the cross objection? Where is it mentioned?
Yes. लोग से पेज लास्ट लोग से ऑर्डर में लिखा हुआ है पेज पारा 34 लोग The present appeal is dismissed on contest with post against the contesting respondents without post against the non-contesting respondent. The cross objection of the respondent number 5 is dismissed.
Not considered कैसा बोल रहे
इसमें एक लाइन खाली लिखा है और कुछ नहीं लिखा है हमारे क्रॉस ऑब्जेक्शन में भी सही एक लाइन लिखा हुआ कहीं कुछ नहीं लिखा हुआ The finding of the letter lower court that defendant number 1 to 4 have proved their title over the suit is hereby set aside. ऐसा कोई फाइंडिंग्स लेकिन ट्रायल कोर्ट का नहीं आया है with a modification the judgment and detail so and so is hereby affirmed.
Para 32 में आएगी. The point of determination is answered that although the learned court is right in recording finding that the plaintiff has failed to prove his title over the suit land, and the learned court is also right in recording a finding that the defendant number 15 has failed to prove his title over the suit land. अब कैसे बोलता है आपका क्रॉस ऑब्जेक्शन नहीं डिसाइड हुआ?
But there is no clear of the I am the defendant. I am the
Para number 32 is a full-fledged consideration of your cross objection.
Yes. Para
आप कैसे बोल दिए कि सिर्फ एक ही लाइन बोला?
Lordship, para 32 Lordship, page 20 Lordship.
Page 19.
Page sample.
Para 32.
That defendant number 15 has challenged the judgment and decree in contesting procedural that learned lower court ought to have said that defendant was having acquired the right title interest over the suit.
आपका क्रॉस ऑब्जेक्शन इसी पैराग्राफ में नहीं है.
Has appended to the procedural register.
मेरिट में बताइए ये कोई टेक्निकल ग्राउंड नहीं है आपके पास.
मेरिट
में क्या है?
हाँ मेरिट में देख पेज 20 में आए हैं पेज 20 में आए लोग पेज 20 में
प्लेंटिफ का क्या केस था भाई ऐसे नहीं होगा ना.
हाँ प्लेंटिफ का केस था कि प्लेंटिफ फाइल टाइटल सूट for declaration of his right title in interest and confirmation of possession and during the pendency of the suit if the plaintiff is found not in possession of the suit like a decree for recovery of possession be passed and cancellation of sale deed dated 23/1979 executed in favor of the defendant number 1 to 4 Lordship. The case of
And who is defendant number 15?
defendant number
15.
defendant number Lordship purchaser of the land from the defendant number 1 to 4 Lordship. Facts
Just a moment. Defendant number 15 is purchaser.
पारा 3 से एक बार पढ़ देंगे facts को.
Defendant number 1 to 4.
एक बार पारा 3 से हम
एक
facts पढ़
second.
देंगे.
कहीं दूसरा जगह जाना है.
नहीं कहीं नहीं जाना.
तो शांति से बस. कोई हड़बड़ी मत रखिए. दूसरा कोर्ट में जाना है वो पे घूम.
नहीं नहीं तो facts में दिखाना चाह रहे थे पारा 3 से कि प्लेंटिफ का केस क्या है डिफरेंट केस
मेरा स्पीड आपकी तरह नहीं है. बहुत स्लो सोचें.
ऐसे ठीक.
Finance. Defendant number 15 is the purchaser from defendant number 1 to 4.
जी.
And suit was filed seeking declaration of title. Title on what ground? On the basis of some sale deed? On what ground?
इसी थोड़ा सा हम facts पढ़ना चाह रहे पारा 3 से.
Right.
Para 3 the case of the plaintiff will be the land pertaining to khata number 1 of village change in measuring total area of 37.2 acres was recorded in last cadastral survey and settlement operation in the name of two ex-landlords namely Bhigunath Sahai and Jagannath Sahai. After disruption between them, they both half share each in the said land. Bhigunath Sahai had no issue and his wife agreed decision. The Bhigunath Sahai transferred his half share in favor of one Harrier Prasad by registered sale deed of gift dated 9/8/1914 and Dhoni came in possession thereof after acceptance of same. Bhigunath Sahai died on 10/3/1943. Thereof Jagannath Sahai instituted a title suit number 30 of 1945 for declaration of alleged deed of gift to be void inoperative. The said suit was contested by Sandhu Saran and Bhim Sam Prasad, sons of late Harrier Prasad, and suit was dismissed on 5/5/1949 with the finding that Harrier Prasad had acquired the title by virtue of deed of gift and he came in possession over the same. Jagannath Sahai during his lifetime settled the suit land under suit khata with plaintiff payment of either tax or procedure, and similarly Sandhu Saran also orally made receipt settlement with the plaintiff and other, out of which the sum settlement will confirm by granting Hukmnama and rate receipt. The plaintiff continued to pay the rent either in cash or produce till the date of vesting to the ex landlord, thereafter to the estate of heir. After death of Hariyar Prasad, his two sons, Sambhu Saran and Hisam Prasad, came in possession over the land and Khata number 1 instituted a range suit number so and so against the city, including the plaintiff and
Shambhu Sharan and Bishop Prasad are the plaintiffs?
no, he is the not plaintiff lordship. The land was settled by Hariyar Prasad to the plaintiff lordship.
Hariyar Prasad?
Ji.
No. Jagannath Sai during his lifetime settled the land of the suit.
To Hariyar
Two
Prasad.
plaintiffs.
Plaintiffs.
Yes. Who is the plaintiff?
The plaintiff is.
Name?
The plaintiff is. The plaintiff is in respondent number 19 to
See,
65.
it is mentioned in para 3 itself that Hariyar Prasad acquired title by gift and then Jagannath Sai during his lifetime settled land under suit.
To Hariyar Prasad.
To the plaintiff.
To plaintiff.
So Hariyar Prasad acquired a title of gift.
Gift.
Then Hariyar Prasad did not settle it with anybody.
No, the plaintiff is just settled by he acquired the land by virtue of Nama lordship.
But the property was already gifted to Hariyar Prasad.
Yes.
But plaintiff is not deriving title from Hariyar Prasad.
Yes.
Then?
I am not the plaintiff. I am the defendant number 15.
I am just asking you.
Yes.
Plaintiff has lost the suit.
Plaintiff has lost the suit.
Okay.
But the defendant number 15 is the procedure of the land lordship.
From defendant number?
1 to 4 lordship.
Who are defendant number 1?
1 to 4. थोड़ा thought पढ़ा देते हैं.
Particular.
That the plaintiff continued to pay the rent either in cash or produce till the date of vesting of the ex land, thereafter the estate of heir. After death of Hariyar Prasad, his two sons, Sambhu Saran and Hisam Prasad, came in possession over the land under Khata number 1 and he instituted a rent suit number so and so against the stately including the plaintiff and their interest of realization of area revenue Jagannath Sai was the performer defendant and he has also contested the suit. It was held in the said suit the plaintiff and their father came in possession over the land under the Bakas Khata number 1 under the same registered DW as the plaintiff and their ancestor acquired the right of the occupancy under the same legacy settlement. Also by virtue of adverse person commencing from the year 1940, Jagannath Sai in order to grab the land of the Rikunath Sai set up on Dukhan Saro by getting a registered sale executed on 12/1/1956 by Srimati Kishori Devi, wife of late Hariyar Prasad with respect to two land under Khata number 1 in possession of the plaintiff. He started to interfere in the possession of the plaintiff, which resulted in closing of the section 44 CRPC. Case number 2 से email the plaintiff and the ancestors were party in Dukhan South. Others were second party. Thereafter was converted into proceeding under section 141 CRPC. Later on, it was referred to the court of Munsi, by the subdivision of magistrate under section 143 CRPC for a finding on the point of possession over the land of miscellaneous judicial case number so and so for the starting the court of Munsi Hyderabad by order dated 7 to 1959. The latter motion to declare the possession of the first party Jiblal Mato and the case record was sent back to subdivisional magistrate Chatra and subdivision magistrate Chatra by order dated declare the possession of the first party. During the pendency of the state procedure, Jagannath Sai make force and file title partition suit number in the court of Munsi Sasaram for declaration that alleged settlement by the son of Hariyar Prasad was not bona fide and also ejectment of the defendant. The suit was contested by the plaintiff who were defendant in the suit. By order dated 6 to 1961, the Legit Munshi rejected the claim of the plaintiff. Thereafter, the civil division number 7 filed before the Muslim High Court, which was allowed and trial was directed to delete the name of Secretary Khata number 1. During the pendency of the title suit number 58, 13058 Dukhan Soil and others filed title suit number 5362 against the plaintiff Jila alias Jila Mahato and others before the court of Munshi Hyderabad for declaration of their title and recovery of possession over the city B land. During the pendency of their title suit, Mithwari Ganju and Hariyar Ganju, who was the defendant first, said that but his heirs were not substituted from the petition filed on behalf of the defendant. That High Court by order dated 22/9/65 held that suit was not admitted as whole, but in a part instead what was confirmed by the Learned First Appellate Court by order dated 21/11/96 in which the civil review was filed with the Honorable Court, and Honorable by order allowed the revision, holding that whole suit has admitted the orders of the court below were satisfied. It is further created with the plaintiff by Jagannath Sahai died leaving behind 5 sons, namely Reti Raman Prasad, Shyamji Prasad, Ramji Prasad, Girvardhan Prasad, and Devraj Prasad. Girvardhan Prasad also died in the legal years having made party as a corporate dependent of 9 to 40, and 4 sons of Jagannath Sahai are corporate dependent of 5 to 8. Reti Raman Prasad and Ramji Prasad Milat having right title interest transfer 15.30 acres land in Khata number of so it was already settled by their father Jagannath Sahai in favor of the different person including the plaintiff. It is further case of the plaintiff that the pertaining Khata number 41 plot number 9 and 6 0.3 acres of the village danger was settled by ex landlord in favor of the Ramdayal Mathavari Purnama against the rent receipt. After his death, his son plaintiff number 1 to 3 came in peaceful possession of the same. The plaintiff number 2 and 3 have both their residential out over the land pertaining to plot to Khata number 1, plot S, 6 and 36 decimal land. They pertaining to Khata number 41, plot number 93, 1.92 acres is recorded is Mahadev Ahar. It is in possession of the state of Bihar. And plaintiff number 4 purchased the same in auction. The defendant number 1 to have committed theft of fees from the state to which the criminal case being trial number 1 instituted they were convicted. In further alleged the defendant had not acquired any title more in possession of suit land under the registered sale deed dated 23/90/79. In further case of plaintiff that the defendant number 1 to 4 were the first time started to claim the right title on the suit land in the basic registered sale deed 15/11/1992 intended to interfere in the harvesting the paddy crop grown by the plaintiff, which casted a cloud over the title of the plaintiff also in this suit. The paragraph defendant number 1 to 5 in their written had claimed the suit land on the basis of the purchase from the rightful of 1979 to consideration of 12% plaintiff was challenging the sale registered deed sale after lapse of 12 years and plaintiff was not in possession over the suit land and possession of these deposits have already been declared. It is further clear that the plaintiff has not fully described the suit land to the boundary. It is further clear that this determined the plaintiff has named Trigunath Sahai, Jagannath Sahai to be landlord of the Khata number 1, only of the village changer, having 8 runners there each, but it is not mentioned that if there was any subsequent survey, what happened in the survey operation and name of the actual land has not been known. The answering have expressed
What is the finding of the learned first
appellate court. The last order with the present appeal is dismissed.
Point for determination.
Point was para
Issue number 6 and 7.
Point was para 22. Whether the finding recorded in the lower court issue higher sustainable of number 5.
Issue number 6 and 7.
6 and 7.
And other was what was the finding of the learned trial court on the point of limitation?
Limitation. Para 6 the issue framed by the learned trial court was the most बनाए थे आधार to पेज नंबर 11 में चुकी है इसी पर से दिक्कत होना इशू नंबर 6 was क्या वादी का बात वर्तमान स्वरूप में पोषणीय क्या वादी को बात पर करने का कारण है क्या वादी का मूल्यांकन किया गया बात को निगम मूल्यांकन न्यायालय से तैयार करते क्या वादी का मान मर्यादा विजय न्याय के सिद्धांत से बाधित है इशू नंबर 4 इज लिमिटेशन लॉस
एपलेट कोर्ट में तो ट्रायल कोर्ट का इशू दिखा रहा है इशू नंबर 4 लिमिटेशन व्हाट इज द फाइंडिंग ऑन
इशू नंबर 4
Issue issue number 4 was decided in favor of the plaintiff.
Para 13 lots.
Yes.
So,
Yes, I've seen. Okay, let us see the point for determination and the findings of the learned first applicant.
para 23 lots. Whether the finding recorded with the net lower court on issue number 6 are sustainable in the act. The plaintiff in para 8 of the plaint has stated registered sale deed executed by the usury in favor of Bhutan South to be
You can
dated.
do the findings straight away.
The point will determine the answer although the limit lower court is right in reporting the finding
You
plaintiff.
read it from page number 14.
Page number
114. 114.
1. Be that it may, the plaintiff by claiming the title over the schedule C of the suit land or Bharti Hukunnama granted by Jagannath signed rural settlement with Sandhu Saran for Sahai for Sanjini, some rural settlement were confirmed granting Hukunnama against him. The plaintiff had brought 3 Hukunnama on the record, in which the first Hukunnama exhibit 3 as per the translated copy of exhibit 3, Hukunnama Sandhu Saran made a 80 section 40 decimal line out of his share and the other number on plot number 820 in favor of beside the land and the Khatan of the subject matter of schedule. Therefore, the exhibit 3 does not support the claim title of the plaintiff. The second Hukunnama, the exhibit 3 by as by the translated copy of exhibit 3 by the Hukunnama Sandhu Saran made the 80 settlement of 72 decimal land of his share and the Khatan number was plot number 562 area and 32 decimal and plot number 82 and area 40 is in favor of the Dilar Mato. The land of Khata number so and so also no subject matter of the schedule C of the land. So exhibit 3Y also does not support the claim of the plaintiff over the suit schedule C land. The third Hukunnama exhibit 9, the Hukunnama has been marked exhibit at the appellate stage of order 5127 procedure. CPC according to judgment passed by the lower court in default of the settlement of the stamp with the Hukunnama could not have been marked as the exhibit, but it has been considered as the lower appellate before the net court below that rectified the Hindi translation of Hukunnama. It was shown that dated 13/11/1953 before the learned court, but he exhibited the same before the appellate court, which exhibit A by J. According to pleading of the defendant number 15, the land covered under exhibit A-G was purchased by Dukhan Rao, the maternal grandfather of the defendant number 15, from the wife of the Harrier Prasad, and after death of Dukhan Rao, the defendant number 15 through his mother acquired the title over the same. The defendant number 15, who himself argued his case, submitted after death of Harrier Prasad, his wife Kishori Devi inherited the land covered under the deed executed in favor of Harrier Prasad by the ex-landlord Jigunath Sahib. Such submission defendant is against the recital made in exhibit A-G. It has come in the exhibit 4 in that is order of the Lord Munshi Harrier Prasad miscellaneous judicial case number so and so that extent participants on another they settled the land covered under the same was settled in favor of Kishori Devi wife Harrier Prasad Sandhu Saran and become Prasad son Hariya also contention defended is against the admission made by the predecessor in the letter. Furthermore, there is no evidence on behalf of the defendant or witness to whether Hariya Prasad died after coming in force of Hindu Succession Act or before coming in force of the act. So his submission is not supported by cogent evidence. It has never been case of the defendant 15 the Kishori Devi inherited land covered under the Exhibit AG. So as a contention has been made first time for the appellate court, which is not enabled in all the appellate court cannot be at the third case. It has come with the Exhibit 4 by the that before the letter to Musi Bhadere was neither any Hikona exhibit Sandhu Saran and Vikam Prasad in favor of Kishori Devi was produced, nor any Jamindari received, no government received in the name of Kishori produced. Any consequently, the letter to Musi found the second party was not possession of the suit landing dispute. The defendant has not been able to prove the title of the Kishori Devi over the suit land covered under the Exhibit AG. Therefore, lower court has rightly gave finding the defendant has not been able to prove his title over the suit land. इसमें जो finding है कि defendant has not been able to prove his title over the suit land because that document was not executed before the
No, not only because of that. The trial court was of the view, since your sale deed on the basis of which you made claim was not exhibited before the court. Right? That was not exhibited before the court.
But it was
exhibited before the
first appellate court lordship.
And your vendor, the Kishori Devi, the defendant has not been able to prove title of Kishori Devi over the land.
But that the sale deed was not challenged by any other party lordship. Any registered document lordship presumed to be correct unless and until it is set aside by the competent court of civil jurisdiction lordship. It is the registered document lordship.
And they have also said that it was contrary to your pleadings made before the court. Where is the question of law in connection with this document?
Exhibit.
This exhibit. Exhibit AG का कौन सा question of law बनाया है? कोई नहीं. यही बनेगा ना और क्या बनेगा?
बस उसी को बनेगा A-G.
Heard the learned counsel for the appellant. It is submitted that this appeal has been filed by the defendant number 15. The learned counsel submits that defendant number 15 had filed a cross objection in the suit.
In the appeal.
सूट में क्या फाइल किए थे? काउंटर क्लेम.
सूट में कम से डिपेंडेंट थे.
अच्छा. Had filed cross objection before the learned first appellate court and had produced the registered sale deed
in the year 1956.
Dated 12/1/1956. The registered sale deed dated 13/11/1956, which was marked exhibit A-G. The learned counsel submits that defendant number 15 was claiming title over the property. the learned counsel submits that the registered salience of the defendant number 15 has been disbelieved by the learned court. Learned first appellate court. Although the same was never challenged by anybody. प्लेंटिफ का टाइटल डिक्लेयर हुआ था फर्स्ट अपील कोर्ट से
नहीं we will plaintiff has failed to prove their title.
The learned counsel has submitted that the plaintiff had failed to prove his title as per the findings of the learned first appellate. तो प्लेंटिफ के सूट से आपका टाइटल कैसे डिक्लेयर होगा?
नहीं मेरा क्लियर नहीं हमारी जो findings are there, the finding the learned the court that defendant has want to prove their title over the suit and he has to state that would be modification. एक finding है कि defendant number 15 has failed to prove title over the suit land. Page 20 और से एकदम नीचे में लिखो. The point of determinacy answer that although the learned lower court is right in recording the finding plaintiff has failed to prove their title over the suit land and the learned court below also right to record the finding that defendant number 15 has failed to prove the title over the suit land.
So, trial court recorded that you failed to prove your title.
नहीं हमारे में ट्राई कोर्ट का नहीं आया इनका आया प्लेंटिफ का आया.
The learned counsel submits that a finding has been recorded by the learned first appellate court that the defendant number 15 has failed to prove his title over the suit property. Correct?
जी.
He submits that a substantial question of law be framed as to whether the learned first appellate court was justified in ignoring the registered sale deed dated 13/11/1956 within bracket exhibit A-G by rejecting the cross objection
जी.
of the defendant number 15.
50.
This appeal is admitted for final hearing on the following substantial question of law: whether the learned first appellate court is was justified in rejecting in holding that the defendant number 15 has failed to prove his title over the property in spite of the registered sale deed number 13/11/1956 within bracket exhibit A-G.
जी.
अब तो काउंटर क्लेम भी नहीं फाइल किया.
नहीं काउंटर क्लेम तो नहीं करेंगे.
बिना काउंटर क्लेम के आपको कोई रिलीफ ऐसा मिल सकता है क्रॉस ऑब्जेक्शन?
नहीं अगर काउंटर क्लेम नहीं फाइल किए हैं तो ऑर्डर 41.2 में हम अपीलेट कोर्ट में फाइल कर सकते हैं.
अपीलेट कोर्ट क्रॉस ऑब्जेक्शन फाइल करेंगे ना, ऑब्जेक्टिंग टू द फाइंडिंग्स रिकॉर्डेड बाय द लर्नेड ट्रायल कोर्ट.
ना तुम तो फाइल किए थे.
Issue notice to the respondents under कितने सारे respondents हैं?
बहुत ज़्यादा है.
सब लोकल हैं,
जैरी
झारखंड के ही हैं सब. विक्रमगंज डिस्ट्रिक्ट शाहबाद, ये कहाँ है?
रेस्पोंडेंट नंबर
28.
तुर्की में है। हम 12 भी पहली बार देखते हैं साहब।
शाहबाद क्या है?
तो डिस्ट्रिक्ट है, तो डिस्ट्रिक्ट लिखा हुआ है।
कहाँ का शाहबाद है? जब इस तरह का एड्रेस होगा तो कैसे
नहीं, जो डिग्री माता उसी को हम लोग लिखते हैं। अगर हम गलत नहीं हो तो स्टाम्प पेपर इसको पॉइंट आउट करेगा। जो डिग्री में आया उसी को हम लोग लिखते हैं।
under ordinary process. For which requisites be filed within a period of 4 weeks. Post on 5th January. Awaiting service.
Requisite be filed within requisite.
One.
1 week.
1 month.
1 month.
इतने सारे लोग हैं यहाँ
Therefore, I'm praying for you.
Item 24, second appeal, 532 of 2017.
May I please? The plaintiff's second appeal against judgment of reversal.
What was the suit for?
Suit was for declaration of title and for cancellation of one certificate.
Your suit was decreed.
Suit was decreed.
Why the learned first appellate court has reversed?
The court appellate court reversed for
Where is the point for determination?
point for determination is page number internal page 11. सबसे lowest minor, lowest.
Please. But
Now the point of consideration before this court is with that whether the plaintiff respondent as such, being the legal heir and successor, has right to challenge the aforesaid sale deed on the ground of non-passing of consideration amount to the vendee in the year 1985, and this court has to further see whether such consideration amount, as mentioned in Exhibit A by 4, has been duly passed to the vendee or not.
so what is your ground?
The ground is not see the admitted case which has been taken down by the government first appellate court himself. Lord, this starts from Lord, paragraph 9 findings. Prior to coming on conclusion, as per reading of both the sides, admitted facts of this case are that the suit land, as mentioned in the plaint, belongs to Ram Narayan Go. The said Ram Narayan Go is the possessor of the plaintiff. It is also an admitted fact that on 8/1/1985, Ram Narayan Go had entered into an agreement for sale with Pradesh Chaudhary, father of the defendant, and on account of legal necessity, said Ram Narayan Go had sold the suit land to Hardev Chaudhary by virtue of registered deed of sale dated 21/3/1985. It is also admitted fact that the respondent plaintiff of this case had filed a suit against Ram Narayan Ahir as defendant number 1 and against Hardev Chaudhary as defendant number 2, and had challenged the sale deed by Ram Narayan Ahir in favor of Hardev Chaudhary regarding the suit land dated 21/3/1985 on the ground that the said sale deed was never acted upon by Hardev Chaudhary, as because the consideration amount as such mentioned in the cell deed dated 21/3/1985 has not been given to Sid Ram Narayan Devi and thereby the said Hardev Chaudhary never came in possession over the land. Now therefore it is important, it is an admitted fact that as per the said cell deed, that is exhibit A by 4, only 1,000 rupees has been shown as paid. It is also admitted fact that Ram Narayan Ahir was died issue days and her wife was predeceased to him. It is also admitted fact that plaintiff Aditya Gop was legal heir and successor of Ram Narayan Ahir. So the right title interest of the plaintiff regarding the asset of the liability of Ram Narayan Ahir shall be saved as the said Ram Narayan Ahir. It is admitted fact that during the lifetime of Ram Narayan Ahir, it has not been decided by any court of law that whether Sindhi as such executed by Sid Ram Narayan Gop in favor of Hardev Chaudhary was null and void on the ground that the consideration amount, that is rupees 4,000, as mentioned in Exhibit A by 4, has not been given by the vendor to the vendor.
There was a previous suit, title suit 12 of 1985.
Yes.
What happened to that?
That suit was not abandoned because of the fact that during pendency of that suit, the defendant number 1 died, and all the right of defendant number 1 was inherited by the plaintiff of that suit. So the plaintiff Aditya Ahir, my lord, has pointed that in Roman 5 that all the right, title, interest of the plaintiff regarding the asset and liability of Ram Narayan Ahir shall be same as the said Ram Narayan. So now all the right was automatically by virtue of law was inherited.
What was the consideration amount of the
4,000?
4,000.
Yes.
Right? Only
Yes.
1,000 was shown to have been paid.
Yes.
What about the remaining
It
consideration?
was not paid. So that's what trial
So what is the finding?
finding is saying that on the basis
That it
of
was not paid.
trial court given a specific finding that it was not paid. They filed an unregistered document alleged to be signed or put thumb impression by wife of the vendor. And relying upon that document, my lord, the first appellate court has reversed. I will show you. Kindly see, my lord, trial court judgment, my lord, I will show from that how that has been come, my lord.
Original deed was exhibited.
Yes, exhibit A by 5.
It was original deed or certified?
Yes.
Original.
No, certified.
That is the original. If you were the purchaser of the property.
No, yes.
Original.
I am not purchaser, my lord.
You are
Purchaser is dependent. I am claiming that this property was not, title of the property has not been transferred by virtue of such.
Okay. No, the point is that this particular property you are claiming by virtue of a registered deed.
Yes.
Where is the original deed? Are you claiming this property by virtue of this deed?
No.
Defendants are claiming it.
Different. Now my case is specific that in the sale deed, consideration amount has been mentioned such and such amount, which has been admitted by the first appellate court. And it is also been admitted, case of the my lord has filed, that it is also admitted that in the sale deed itself, it has been written that the entire consideration amount has not been paid.
Okay.
Now what has happened in that suit, in the earlier suit, Ram, the actual vendor came and he said, so entire consideration amount has not been paid.
So,
Now,
but ultimately that was not taken to a logical end.
not a logical.
So that has got no
Yes,
no relevance.
Not relevant. And thereafter this suit has been filed and the first appellate has court has ignored the contents of the registered deed of sale, which shows that consideration amount was not paid. Only on the ground that one unregistered document has been signed by wife of the vendor कि हमको बाकी पैसा मिल गया, जिसको that has been referred as सफीनामा. Roman 4 my lord admitted fact, my lord, if my lord will have a look to internal page 11 with. Roman 4. It is also admitted fact that as per the said salary dated reply, only 1000 rupees has been sold as.
Read this finding. Just a minute. From bottom of page number 20.
Page
Page 20. Bottom.
yes.
None of the aforesaid contents of the same deed.
None of the aforesaid contents of the sale deed provide that in case consideration amount either in whole or in part is not paid, then title will not be conveyed under the sale deed. There is also not mentioned in the sale deed that payment of the entire consideration amount is a condition precedent for transfer of the title of the suit property. Then therefore assuming for the sake of the argument that plaintiff respondent did not receive the consideration amount under the sale deed, though the defendant had claimed that the entire consideration amount had been paid, the entitlement of the plaintiff will not be for filing of the present suit, seeking for relief for cancellation of the sale deed and the related relief, but for recovery of the balance price allegedly not paid by the defendant appellants. This way, from the perusal of the contents of such sale deed, it is clear that after execution of such sale deed, said Ramlal who had clearly intended to transfer the suit land to Hardev Chaudhary, since from the date of execution of the sale deed itself had also bound himself that he along with his successor in interest shall have no rights over the suit land. Again, in consonance with Exhibit 3, Safinama mentioned this slide for Exhibit C and Exhibit D along with ocular evidence as brought on the record on behalf of both the parties, it is clear that the title as such regarding the suit land mentioned in the schedule of the claim has been validly passed to the vendor. Whereas regarding possession over the suit land is concerned, it is established principle of law that title followed possession. Again, from ocular evidences, although witness of the rival side claimed possession of their respective side, but admittedly plaintiff respondent had not produced any sheet of paper for payment of rent regarding the suit land. Whereas appellant defendants have filed 4 rent receipts which have been marked Exhibit E series. Out of them, Exhibit E is the all rent receipts have subsequent to registered salary. Exhibit E by 3 is the year 1989 in the name of Hardev Chaudhary. Contrary to same, there is no sheet of paper has been filed. Now, a first appellate court has given a finding that it was the intention of the vendor to transfer the land. Now,
You
but
see, you are the plaintiff, right? The defendants have filed this rent receipts. You have not filed it.
how I could find? In the year 1985, salary was registered.
Yes, 85 it was registered.
On the basis of that
Then
registered.
thereafter, all the
Yes.
all the rent receipts have been filed by the defendants.
वही बता रहा हूँ ना. On the basis of that registered deed of sale, mutation was done. Now suit was filed and vendor specifically came before the court and he said in a clear suit that deposition has been exhibited and he specifically said that there was clear cut
Which
stipulation.
exhibit?
Well, just showing from the trial court certificate, can you have a look?
Exhibit his deposition in which case?
In the earlier suit.
Earlier suit, what happened to earlier suit?
Earlier suit
If
was
it was not taken to a logical end, then how its evidences can be?
Person who is dead.
No, that's right, person who is dead, but you see the finding.
Finding is there that the vendor was intended to transfer the land. This is the finding.
Yes.
Now, but this finding is contrary to the deposition by a dead person in earlier proceeding. A person is dead, vendor is dead, but when vendor was alive in a judicial proceeding, he came, he confronted in the dock with the court, and he said, no, this was the consideration, entire consideration amount was not paid, so title was not passed, and it was not the intention to transfer the title. So now the only question, if entire consideration amount is not paid, then whether evidence of that vendor could be ignored by the learned first appeal court by reversing the judgment decree.
That was exhibit number?
Yes, my lord. From trial court, my lord, I will show.
You show me, you give me the exhibit number.
My lord, A by 4.
A by 4 is the same thing.
No. Sorry. A by 4.
That is not there.
नहीं.
Which is that?
Just. A by 4 में उन्होंने लिख दिया. Just. My lord, exhibit 9, my lord. It is internal page of 5 of the trial court. इसी वाद में रामनारायण भोग द्वारा बतौर प्रतिवादी सच्ची संख्या दी गई गवाही की अभिप्रमाणित सच्ची प्रतिनिधि.
This has been fully considered by the learned first appellate court at page number 18.
Yes, sir. Can you see?
Yes, it has been considered.
Considered, but my lord, the specific evidence in exhibit 9, which has been brought on the record as verbatim by the learned trial court, that has been ignored. I will show from the trial court. Kindly see. Internal page 8 of the trial court. Internal page 8.
Yes.
स्वीकृत रूप से पक्षकारों के बीच पूर्व हकवाद संख्या 12/1985 लड़ी गई थी. उक्त हकवाद में इस विवादित निबंधित पट्टा के विक्रेता राम नारायण अहिर गोपीय प्रतिवादी थे एवं स्वीकृत वाद में पूर्व वाद में वे बतौर प्रतिवादी संख्या 1 परीक्षित हुए. उन्हीं गवाह की सच्ची प्रति वर्तमान वाद में प्रदर्शन है. स्वीकृत रूप से यह साक्ष्य मर चुके हैं. इनको वर्तमान वाद के उभय पक्षकारों द्वारा पूर्व वाद में पूर्णतः प्रति परीक्षण किया गया था. पूर्व वाद में भी यह एक विवादित बिंदु थी कि विवादित बिक्री पट्टे की बिक्री में अदा की गई थी या नहीं. अतः मेरे विचार से प्रदर्शन भारतीय साक्ष्य अधिनियम की धारा 33 की सकल शर्तें पूरी करती है एवं वर्तमान वाद में इसकी प्रासंगिकता है. प्रदर्शनों के अवलोकन से पाया जाता है कि क्रेता राम नारायण अहिर के विरोधाभासी कथन दिए हैं. मुख्य परीक्षण के कथन खंडिका 3 में कथन करते हैं कि विवादित जमीन का बिकने वास्ते प्रतिवादी संख्या 2 हरिदेव चौधरी के साथ 10,000 रुपये में किया था, पर हरिदेव चौधरी ने 5,000 पर हरिदेव चौधरी से 5,000 रुपये मुझे कभी नहीं मिला, बल्कि उसने मुझे सिर्फ 100 रुपया दिया. प्रतिवादी संख्या 2 वर्तमान वाद के प्रतिवादियों के पूर्वज को सफीनामा दिखाते हैं जो वह प्रति है. प्रतिवादी के अनुसार विवादित पट्टे के विक्रेता राम नारायण अहिर वो प्रतिवादियों के पूर्वज हरिदेव चौधरी के
अभी तो डीड में लिखा हुआ है कि 1,000 रुपये.
हाँ.
ये 100 रुपये का काम था सर. डीड में लिखा हुआ है at the time of execution of the deed 1,000. Then how is evidence is saying that 100 rupees was only paid?
thereafter can be come, thereafter may not be. यह राम नारायण अहिर उर्फ वो अपने प्रति परीक्षा के खंडिका 7 में इस इकरारनामा पे अपने हस्ताक्षर को स्वीकार किए हैं। इस इकरारनामा पर 10B एवं
You see, this particular piece of evidence has been appreciated by the learned first appellate court, and the court has come to a conclusion that you have taken a U-turn. This Ram Narayan Gop had taken a U-turn after receiving the consideration amount.
Now, but yes, now my lord will find that from the next paragraph that even consideration amount from exhibit A by 4 is 5,000 kindly come. यह राम नारायण अहिर वो अपने प्रति परीक्षण के खंडिका 7 में इस इकरारनामा एवं विवादित मूल बिक्री पट्टा के अवलोकन से स्पष्ट हो जाता है कि बिक्री मूल कुल 5,000 रुपया तय। Now this is admitted by the defendant that the remaining amount, entire consideration amount was not paid. Next comes to page paragraph 12.
Yes, what is the consequence of non-payment of the entire consideration amount?
Sale title will not.
But the court has come to a conclusion that you can sue them for remaining consideration.
No, that is option.
This
Yes,
is what?
yes. Now that is that option. My lord is well aware if any contract is voidable, that is always at the option of the one party, either to accept that document or come to the court to declare that no, that this document is voidable. So I have not accepted that. I came before the court. No, this document is voidable. Kindly see paragraph 12. And thereafter, my lord, there is a specific finding that प्रतिवादी स्वयं यह स्वीकार करते हैं कि विवादित पट्टे के निबंधन के समय पैसे का भुगतान नहीं हुआ।
डीड में लिखा हुआ है कि 1,000 रुपए
हाँ,
मिला
नहीं,
तो जो आदमी मर गया उसका फिर डीड मानेंगे कि नहीं मानेंगे?
नहीं, डीड में जब लिखा हुआ है कि 5,000 रुपया है और उसमें अपीलेट कोर्ट भी बोले हैं कि नहीं एडमिटेड केस है कि only 1,000 has been paid, entire consideration amount has not been paid. So totally dependent upon the consideration. Now that is true that I could file for recovery of my money, but that is also true, my lord, that this is settled law that if a document is voidable at the instance of any party, and either it has also option to accept this. I have not accepted. I came before the court that this is voidable. Kindly, only one paragraph admission I will show in internal page 9 of the trial court judgment. प्रतिवादी संख्या 2 इसी केस बतौर प्रतिवादी संख्या 1 अपने प्रति परीक्षण खंडिका 34 में निम्न कथन दिए हैं। 21/3/1985 मूल प्रदर्श A/4 एवं प्रदर्श 5 के निबंधन की तिथि को रजिस्ट्री के समय रुपया राम नारायण गोप को नहीं दिया गया। This is the admission. That's why the learned trial court. This is not the case. The trial court has not considered. He has also considered the inconsistency. But when this admission was made by the defendant purchaser, my lord, for defendant number 2, the learned trial court thereafter has said that प्रतिवादी स्वयं यह स्वीकार करते हैं इंटरनल पेज 9 पैराग्राफ 12। यह स्पष्ट है कि प्रतिवादी स्वयं यह स्वीकार करते हैं कि विवादित पट्टे के निबंधन के समक्ष पैसे का भुगतान नहीं हुआ।
The court has relied upon section 55(4).
54 and 55 transfer of property है।
55(4)
Yes.
कुछ है क्या?
है।
Transfer property. This says that if the entire consideration amount has not been paid, then you can sue for the. Does it
55
make?
में नहीं
Does it make the
55 देख रहे नहीं
54?
हम देख रहे नहीं है मेरे फेवर में हाँ देख लीजिए फेवर में है कि सेल तभी होगा जब कंसीडरेशन और जब डिफेंडेंट खुद एडमिट कर रहे हैं कि नहीं हम पेमेंट किए देन लर्नड ट्रायल कोर्ट हैज डिक्रीड माय वो मेरे फेवर में देख लीजिए
You see 55(4) का B आप पढ़ी ट्रांसफर प्रॉपर्टी एक्ट you did it you did 55(4) दीजिए ट्रांसफर प्रॉपर्टी एक्ट
where the ownership of the property has passed to the buyer. Yes, so first it should be satisfied when ownership of the property has passed to the buyer before payment of all of the purchase money through a charge upon the property in the hands of the buyer, any transferee without transferring purchaser without consideration or any transferee with notice of the non-payment for the amount of the purchase money or any part thereof remaining unpaid for interest on such amount or part from the date on which possession has been delivered. So this is the wise. It will be
No,
wise.
therefore, on the basis of this provision, the court has said
Yes.
that you could have sued for the remaining consideration amount. But on that ground, non-payment of part consideration amount will not be a ground
No,
to
so-
set aside the
Yes,
same.
my lord is correct. Now, for that purpose, my lord, one exhibit, one document was brought on the record, which notice was given by the Ramdehi vendor himself that you have not paid.
No, that's right, but part amount has been
Even
paid.
now,
The court says that if there is a registered security and only part amount has been paid,
or any part
and the title passes to the purchaser, there is no bar in deferred payment of consideration amount, right? There is no bar. And if only part payment is made at the time of registry, then this will not be a ground for cancellation of the
yes,
same.
then you will have to show 55 more. You have to give a notice. My lord, just now kindly see exhibit this one, my lord. Just showing.
We need to rise right. The arguments have remained inconclusive. Post tomorrow.
Actual pay, my lord. First of all, तो करने थोड़ा जाना रखिए.
Yeah.